My name is Natalie Bowers and I'm an Associate Solicitor at WBW Solicitors, and I specialise in all matters care related.
My name is Craig Richards. I work as a financial planner at WBW Chartered Financial Planners.
There are national rules about who has to pay for care and support in later life, but the application of those rules can vary slightly to a small extent depending on where you live in the UK. This presentation is intended to cover the situation for people living in England and particularly within the South West. The cost of care and who has to pay what towards it mainly depends on the type of care and support that you need, where you live and what is available. If you are still living at home, you will usually pay for the cost of your own care and support. The local authority or council may also contribute, but this depends on your income and your assets, such as savings or shares. You may be assessed by your local authority as having to pay for some or all of your own care and support at home. This is sometimes called being a self-funder. If you are receiving care and support in your own home, you are entitled to keep a basic level of income, money you receive regularly, however much your care costs. The Care Act states that charges for care must be reasonable. If you are living in a care home, you might pay for all of your care and support costs, which means that you are a self-funder. Or you may make a contribution with a local authority and/or the NHS also contributing. Again, this depends on your income and assets and on your needs. The aim of these videos is to show you what the cost of a care and support regime might be, to explain what financial assistance may be available from the state, to highlight the various options which may be available to fund and care you are required to pay for, to highlight why it is important to think ahead and plan for the cost of care, and finally, to show you that our pretty unique ability to provide integrated legal and financial advice can be relied upon to help you do exactly that. A good starting point is to consider, if you do develop care needs at any stage in life, how much you may need to spend in order to provide yourself with appropriate care and support. Lang & Buisson are leading independent analysts of the UK care sector. Their latest annual Care of Older People UK market report shows that the average fee paid for an average room in an average care home in the southwest of England by older people aged 65 and over was as follows. Lang & Buisson also forecasts that care costs are likely to increase at a higher rate than the rate of general household inflation for the foreseeable future. There are various reasons why it thinks this, but the main ones are that demand is likely to continue outstripping supply, there is a national shortage of care staff, carers' wages are likely to have to increase substantially, and finally, that continued pressure on public funding is likely to mean that self-funding residents will see proportionately higher increases in the cost of private care. We have certainly seen increases of at least 6 to 8% per annum in our client base over the last 12 months. We have also seen increases of over 10% per annum in some cases if the care home in question is particularly sought after or if any kind of specialist care, particularly dementia care, is required. The cost of a care regime in later life doesn't just depend on how much the care is likely to cost, it also depends upon how long the care is required for. And the length of time you require care and support is very likely to vary according to gender, your state of health, and your socio-economic group. The latest available averages, published by the Office for National Statistics in 2021, are as follows. Partnership Assurance, which is an insurance company that specialises in meeting the needs of people in later life, has also conducted some more detailed research which suggests that there is some evidence that people who fund their own care tend to live for longer in care homes. This is thought to be possibly due to them coming from certain socio-economic groups and therefore possibly having a better health and a better quality of life up until the point that they developed care needs. So taking both the cost of care and the length of time that care is likely to be required into account, the cost of an average care regime in later life for someone who lives in the Southwest is likely to be as follows. Because females tend to require care for longer, their costs are likely to increase. The government has promised that it will cap the amount someone has to pay for their care at £86,000 from October 2025. But it has made promises in the past on this, which it has failed to keep. And even if the cap is introduced, the smoke and mirrors which surround it mean that in reality most people will pay a lot more than £86,000. Our analysis and calculations estimate that even if the cap is set at £86,000, most people will have to spend at least £180,000 before they actually hit the cap. And even if they do, they will still have to pay an extra £2,000 per month thereafter towards their care. It is also the case that any costs incurred before October 2025 will not be taken into account. So anyone who is already paying for care or who needs it before that date will actually end up paying a lot more. The end result is that the cap, even if it is introduced, is very unlikely to reduce the amount many people pay for their care by very much, if anything. The 2021 Lang & Buisson Market Report also shows that the average hourly rate for domiciliary care provided in the southwest of England was at that time £15 to £30 per hour. Note that the hourly rate differs really quite considerably between different care agencies, and there is potentially some evidence that you receive the service that you pay for. The cost of full-time live-in care, i.e. 24 hours a day, 7 days a week, was an average £1,300 per week or £67,600 per year. But this can work out proportionately cheaper if a couple require care. In this case, it's usual for a supplement of £150 to £300 per week to be charged, rather than the individual fee to be doubled. So for a couple full-time live-in care probably costs on average around £80,000 per annum. That actually is slightly cheaper than it would cost to provide care for two people in a residential care setting. Given the costs involved, who pays for care is a hugely important question when those in need of care or family members face the reality of needing care. Essentially, there are 5 steps to consider, starting with a request for what is called a needs assessment. Local authorities have a statutory obligation to assess care needs of individuals, regardless of whether they say that person is required to pay for their own care or not. Some care services must be provided free of charge, such as aids or minor adaptations to the home, costing less than £1,000, or intermediate care, including reablement for up to 6 weeks. Others are free, based on local authorities' discretion, although budget constraints are starting to impact on such services. It is important to understand the difference between health and social care. If your needs are primarily medical, then you may qualify for free care via what is called NHS continuing healthcare funding. Eligibility for this is not straightforward, and we would urge you to seek advice and guidance in this respect. The next step is to claim whatever state benefits you are eligible to receive. You can claim attendance allowance if you meet all of the following criteria. You're over state pension age, you have any type of disability or illness, including sight or hearing impairments, or mental health issues such as dementia. You could benefit from help with personal care, such as getting washed or dressed, or supervision to keep you safe during the day or at night. You have needed help for at least 6 months. If you're terminally ill, you can make a claim straight away. You can claim carer's allowance if you spend at least 35 hours a week caring for a disabled person where you don't have to live with them or be related to them, or if you care for someone who receives either rate of attendance allowance, or if you do not earn more than £132 a week after deductions, or a state pension of more than carer's allowance, or if you are not in full-time education. It is important you are in receipt of any state benefits to which you are entitled, because the local authority financial assessment to determine whether you will pay for your social care in full or in part will assume that you are in receipt of these when they work out how much they will pay. We can access detailed personalised benefits checks and assistance with claiming any benefits which may be available through a commercial arrangement with Citizens Advice. We do charge a nominal amount, but in exchange we can provide prompt assistance which is tailored to your exact requirements. NHS Continuing Healthcare Funding, otherwise known as CHC, is a package of care for adults over 18 that is arranged and funded solely by the NHS. The CHC process is set out in the National Framework for NHS Continuing Healthcare Funding and NHS funded nursing care, and if a person qualifies for CHC funding, the full cost of their care will be paid for by the NHS. This can be in a care home or in a person's own home. To determine eligibility for CHC funding, assessments will be carried out by a multidisciplinary team consisting of representatives from both of the NHS and the local authority, together with any other professionals required, in order to ascertain if a person has a primary health need. The first assessment is carried out using the checklist tool and will identify whether a referral for a full assessment of eligibility is required. The professionals involved will then consider the 12 domains of care, which include breathing, nutrition, continence, skin, mobility, communication, psychological and emotional needs, cognition, behaviour, drugs or medication, altered states of consciousness, and any other significant needs. These needs will be scored based on level of need, and if the relevant criteria are met, a referral for full assessment will be made. The decision support tool will then be used to carry out a more in-depth assessment of the 12 domains of care, again using a scoring system, and if certain criteria are met, a recommendation for CHC funding should be made. The multidisciplinary team will also consider the nature, intensity, complexity and unpredictability of need, and if these can be evidenced, a recommendation for CHC funding should be made. In the event that a person has a rapidly deteriorating condition and where that condition may be entering a terminal phase, a fast-track assessment should be requested. This essentially means that an urgent referral for assessment is required. In the event that a person doesn't qualify for CHC funding, they may qualify for NHS funded nursing care, and the NHS will pay a flat rate, currently £209.19, directly to the care home. The CHC assessment itself will run from the date that the assessment was requested, but will not consider the care needs of a person prior to the assessment. Retrospective reviews for previously unassessed periods of care can therefore be requested and should be considered seriously. WBW Solicitors has had success in conducting these reviews, with one of our clients having the sum of over £100,000 plus interest being repaid to the client.
Only the income of the cared for person can be taken into account in the financial assessment of what they can afford to pay for their care and support. Where this person receives income as one of a couple, the starting presumption is that the cared for person has an equal share of the income. Income includes state pension, private and company pensions, investment income, which includes interest, dividends, rental income and anything else. Trust income is possibly accessible depending on the form of trust. Certain forms of income paid to military veterans and their widows or widowers are excluded from assessment. The treatment of state benefits is complex, and accessibility partly depends on whether care is being received at home or in a residential setting. The key income exemption is that if a spouse or civil partner receives a private or company pension, 50% of it can be transferred to their partner or spouse and achieve exemption. Transfer and other income, whether it also involves transfer and ownership of the asset that produces it, is unlikely to prevent it being assessed. We will look at this point in a bit more detail later on. A local authority must leave you with a certain amount of income. If you live in a care home, it must leave you a personal expense allowance of £27.19 per week to spend as you wish. If you receive care in your home, it must leave you with at least a minimum income guarantee once all the charges you pay for care have been taken into account. The minimum income guarantee is currently £194.70 per week if you're on your own, or £148.65 if you live with a spouse or civil partner. A higher amount can apply if you qualify for a disability premium and you incur additional disability-related expenditure. Local authorities also have discretion to exempt some of your income or increase your personal allowances. If applied, the normal rules would cause you or someone you live with financial hardship. Having said that, it is very rare to see local authority exercise any discretion in the current environment. Very few people are able to meet the cost of care out of their income alone, so almost always an assessment will move on to look at your capital. Again, the assessment should only consider the capital belonging to the person who requires care, and again, any capital which is held in the name of a spouse or civil partner should not be assessed. And again, there are rules which potentially render a transfer of ownership to your spouse or indeed anyone else ineffective. We will look at that in due course. Capital can mean many things, and indeed the statutory guidance in England gives local authorities the flexibility to consider the individual assets on its merits. That said, it is the amount of money you have added together minus any debts. Any joint accounts are generally treated as an equal split. Capital does include bank and building society accounts, national savings certificates, premium bonds, stocks and shares, shares in a family business, regular savings and investments including ISAs, any houses or commercial properties you own. Your home is potentially exempt from assessment under various different scenarios, which we'll look at specifically in a minute. Investment bonds with a life assurance element. Note the term bond is used in all sorts of contexts and most forms are accessible. We can look at any bonds you may own and let you know whether yours are or not. Personal possessions, gallantry awards. Once the extent and the value of your assessable capital has been determined, the amount you have to pay for your care will be determined by reference to the National Capital Assessment Limits. You will have to pay the full cost of your care if your capital is greater than £23,250. If your capital is under £14,250, you won't have to contribute anything of your capital. Capital between those two figures, you will have to contribute from your capital at a rate of £1 per week for every £250 of capital. This is known as tariff income. Note that the value of an asset is deemed to be its open market value. The value of most assets is very clear, i.e. the amount of cash held in the bank or the value of most investments is pretty obvious. But some assets, such as an interest in a family business or in real property, is potentially debatable and may need to be professionally calculated. The value of your home may or may not be assessable, and whether or not it is depends upon your circumstances. If you are being assessed for care at home, your home is the care setting and its value will be excluded from assessment. If you are being assessed for residential care and you own your own home, its value will be taken into account unless it qualifies for exemption. There are 4 main exemptions. The value of a home is exempt until such time as care is deemed to be permanent. Your home is not accessible if residential care is temporary. For example, you are having a bit of respite care, or you've been placed in a care home as a halfway house on your way home from hospital. It is also exempt from assessment for the first 12 weeks of permanent residential care. And it is also exempt if your spouse or civil partner continues to live in the property, regardless of whether or not they actually own an interest in it. It is also exempt if it continues to be lived in by a close relative who is incapacitated. They receive or would qualify for a disability benefit, who is also aged 60 or over or is a child. The local authority also has discretion to ignore the value of the property in special circumstances, such as if it's the only home of someone who has been a long time living carer, particularly if they don't own a property of their own. In the current environment, it has to be said though that local authorities probably will not exercise discretion favourably. Where it transpires that the value of your home is assessable, the market value of your interest will be taken into account to determine how much you have to pay towards your care. If you own the property jointly with someone else or with a trust, it may be quite complicated to work out the value of your interest. The value of your share is likely to be lower than a straightforward proportion of the total value of the property. The value of a part share in the property could be very little, next to nothing or zero. One very important point is that even if the value of your home falls into assessment, this does not mean the local authority can force you to sell your house. There are various ways you can use the value of your home to help pay for your care without having to sell it. These include renting it out, taking out equity release, and enter into what's called a deferred payment arrangement with your local authority. Various options may be available, and it is definitely worthwhile taking some specialist financial advice before you make any decisions. Another key point is that if a spouse or civil partner continues to live in your home after you enter residential care and they change their mind and decide they want to sell, it is also very important that they take advice. They need to fully understand the financial implications involved and whether this could affect either the amount you pay for your care or the amount they will have available to rehouse themselves. I mentioned earlier that giving away income or transferring the ownership of an asset is unlikely to stop it being caught by a local authority financial assessment. Anyone giving away their income or their assets simply to avoid having to pay for social care is likely to be caught by what are known as the intentional deprivation rules. The rules are basically designed to catch people who have intentionally deprived or decreased their overall assets in order to reduce the amount they are charged towards their care. A local authority is required to show that avoiding the care and support charge was a significant motivation for giving away or disclaiming the income or asset. Essentially, this means it needs to consider two things. At the point the capital was disposed, did the person have a reasonable expectation of the need for care and support? Did the person have a reasonable expectation of needing to contribute to the cost of their care provision? If the local authority deems that they have deliberately given away money, property, or other assets for this reason, the local authority can assess the person's finances as though the asset or income had not been given away. In some circumstances, the local authority has the power to recover fees directly from the beneficiaries themselves. Alternatively, if the income or asset in question has been given away to a third party, the authority is also able to pursue the third party. Generally speaking, local authorities are becoming increasingly aggressive in applying the rules on intentional deprivation of assets. Always seek advice from a professional before considering gifting away any income or capital assets. It is always important to consider that income and capital that you are entitled to can also be taken into account even if you don't actually receive it or own it. The rules relating to notional income and capital are an extension of the intentional deprivation principle. They apply where income or capital would be available to someone who is receiving care, but for the fact that they haven't actually taken ownership of it. Prime examples are a pension which is available to you, but which you haven't yet actually turned on, an inheritance which hasn't yet been distributed to you, or a lottery win which you haven't yet formally claimed. Basically, the rules allow a local authority to treat the income or capital as being received, regardless of the fact it may not technically be so. The basic objectives of financial planning in later life are probably to ensure your financial security for the rest of your life and maintain the value of your estate as far as it is feasible to do so. Depending on your circumstances, there could be up to 9 different care fees or funding options available to you. The really important point is that it's best to consider all the options that are available, and professional advice can identify which one, or more likely which combination of options, will work best. The first 4 options involve the use of residential property. The first 2 will enable you to continue living in your home. These are downsizing, which means selling your current home and moving to a less valuable one, thereby releasing funds to meet your care fees. And then equity release, which means you stay in your current home, but you borrow against its value to raise additional cash. The other 2 options are only available if you leave your home and move into a residential care setting. This includes entering into a deferred payment arrangement with your local authority. The local authority will take a charge on your home, which will allow the local authority to help settle your fees. And the charge will be settled either when you pass away or when your property is sold. The 4th option includes renting out your property, which will generate additional income that can be put towards the cost of your care. There are 5 other ways self-funders can consider paying their fees. The first is holding and using cash. The second is holding and using investments. The third is using pension funds. And the 4th option is purchasing an immediate care fees annuity. The final option is that if you haven't got sufficient capital of your own to pay for the care you want, then you can see if anyone, usually a family member, is able and willing to make up the shortfall between your care costs and your income. This is known as a third-party top-up. We have a very established process for looking at all of the options, which are available to you taking into account your circumstances. It is always advisable to seek professional advice on these matters before taking any formal action.
It is hugely important to note that whatever financial plans you have put in place to meet the cost of care can come crashing down in an instant if you lose the capacity to give instructions to your family and/or your professional advisors. The most common reason why this happens in later life is the development of some form of dementia, and there are several of those. People sometimes think that if their mental faculties fail, that their spouse or children can simply step in and deal with their money or make decisions about how and where they receive their care. This is a complete myth. The legal position is that if you have not made a power of attorney to formally appoint someone to take over the management of your affairs and any decisions that need to be made regarding your care, your finances are effectively frozen and the state will make decisions about your care until somebody else has been formally appointed. That formal appointment is called a deputyship. Obtaining one of these involves a lengthy court process which will take several months at significant cost. The decision as to who is ultimately appointed will be made by the court rather than by your family or friends. The court will decide what decisions the person can and cannot make without its approval, and whomever is appointed will have to regularly account to the court regarding the decisions that they have made. The alternative is that you decide to appoint someone you want to make decisions on your behalf whilst you retain the capacity to make that decision, and you formally appoint them to act on your behalf by making a document called a power of attorney. There are 2 forms of power of attorney. One appoints someone to make decisions regarding your property and financial affairs. The other is to appoint someone to make decisions regarding your health and welfare. We strongly recommend that you make both. The financial power is absolutely vital because if you don't make one, there is a very real risk your financial plans could be badly thrown off course. Not making a health and welfare power of attorney could result in the NHS or your local authority taking full control of when, where, and how you receive care and support in later life. The key point is that the state's definition of what is in your best interests might well be very different to what you and/or your family might think. So why bother planning for paying for care? We sometimes hear people say, well, if I run out of money, the local authority will pick up the bill for my care, so why should I worry about planning for the cost of my future care? To some extent, that's a logical response, but only if it is an informed one. The first thing is that local authorities are legally allowed to cap the amount they pay for care, and typically they only pay a specified set rate for care. In most cases, and certainly in the Southwest, the local authority rates are well below the cost of an average room in an average care home. Therefore, if your money runs out, you may find there is a big gap between the cost of the care regime and setting which you would like and the one which the local authority is prepared to fund. If no one else is able and willing to bridge that gap in funding, you could find the local authority relocates you to a different care home in a very different location to the one which you have been living in or want to move to. If this happens, it can obviously be extremely distressing, and it can mean that your family and friends have to travel a lot further to visit you. The other key point is that a local authority is only required to pay for care where there is a real care need. If you have chosen to move to a residential care home simply because you thought it was more comfortable, practical, or less lonely than remaining in your own home, it could be that the local authority can legally refuse to pay anything towards your residential home fees. The local authority is only required to pay if you have eligible care needs, as defined by reference to national criteria. If your own money runs out and you don't have those needs, the local authority would probably have to house you somewhere, but it wouldn't have to house you in a residential care home unless someone else is prepared to pay the bill. Before going into a care home, it is important to review and understand the terms of the contract. This should be clear on what you can expect to receive, the complaints procedure, and the fees that you would be expected to pay, and when these may change, and include other important terms such as notice periods. The fees that you pay will depend on whether you are a self-funder and what happens if your fees fall to the threshold of £23,250 or whether you need financial assistance from the local authority. A good contract will be clear and the conditions should be plain. This should cover, for example, the type of accommodation that you can expect, such as room size or location within the care home, full details of fees and in what circumstances that these can be increased, for example, due to a change in care need, whether there are any additional charges, for example, for chiropody or hairdressing, whether any deposits are required, and in what circumstances would you or your legal representative be able to obtain refunds. Will you continue to be charged if you are away from the care home for any reason, for example, if you're admitted to hospital or go on holiday? Details of any trial period during which the resident can terminate the contract. And the complaints procedure should also be clear. Under consumer law, if a term in a contract is deemed to be unfair, then it will not be valid. This could include, for example, excessive cancellation fees or hidden charges, being unclear about how fees are calculated, attempting to limit your legal rights, and limiting or even removing the care home's liability where the care home has failed in its duty of care to the resident or their possessions. Reviewing the care home contract will give you or your legal representative, for example if you are acting as power of attorney for your mum or dad, the ability to ensure that you understand the terms of the contract before you agree to go into care. For more information on any of the topics discussed today,
or to arrange a no obligation appointment, contact me, Craig Richards,
or myself, Natalie Bowers.